What's up, Legal Research and Writing 2? Prof. Murphy here, and today I am in front of a local law office in my hometown of Farmingdale, New York. So now we know that the memo isn't about the court. It's not a court document. It's not for our adversary to see or the judge to see. It's internal, like in the law office behind me. But then that begs the question, how do I write it? What's the format? How should I approach it? Where do I begin? So today we're talking about writing that legal memo. Legal memo drafting. Let's not waste time. Let's get right to this. So I have over here, I'm going to pull it up, a Word document, and we're going to get right to work. The two issues that I will be addressing are both of the issues relating to contributory negligence. So that is whether Hessler engaged in serious illegal conduct, barring his recovery, and assuming he did not do that, what percentage of fault do we think will be attributed to his conduct? So I'm going to make this bigger. That is, whoa, too big. How did it get that big? That's crazy. These computers. It's like he's having fun. All right. So what do I start with? I start with the heading. 2. Who is this to? We'll say senior partner. From. Be your name. And what I'm doing there is between each one, I'm just leaving a space and I'm tabbing it as well. Another space. Date. So today's date is, Today's date is October 6th, 2020. And last but not least, regarding client's name. Edwin Hessler. Boom. Okay. Y'all with me so far? I hope so. That was easy. All right. Now, here's what I'm going to do. We know I'm not going to write every section in the order, but what I'm going to do is leave little placeholders so I know what sections I need to include. So the first one will be facts. So I'm not going to write it now, but I'm going to include it so I know it's there. I got to come back to it. Facts. Second section would be the issues. We know there's multiple issues. I'm writing a memo on 2 issues today. All right. Discussion, of course, and stylistically, I like to do this. Like I use underline and bold, just so people can clearly see the delineation or distinction between sections. Stylistically, do it your way. It's just there's no right or wrong way to do that. It's just a matter of it looking neat. Like, don't do facts like in italics and like make it red or something and then do the rest. Like, you know what I'm saying? Just keep it all consistent. Just make them all look the same. Make it look nice and neat. And then, of course, last but not least, we have our conclusions. All right. But we know where we got to start. We got to start with our discussion, right? And in this discussion, again, I'm going to do some more organizing right now, actually, to make this, again, nice, readable, easy format for the attorney who might be reading it. So we're dealing with the two issues under New York CPLR 1411, and we know one of them is serious illegal conduct. So what I'll do is here, I'm going to mix this up a little bit so it looks different. Serious illegal conduct, barring recovery, right? And then we know that the other one is percentage of fault. Percentage of fault, right? So that way, even within, if there's multiple issues, hint, hint, there's multiple issues in your final memo, the reader of it can jump from issue to issue if they so choose. All right. And with that, let's get started. So I like to use this justified both sides. I think legal writing just looks sharp when it's done that way. But we know that our first issue relates to the whether Hessler engaged in serious illegal conduct that will bar his recovery. So a good place to start is with the statute. Okay? So the statute says, well, it doesn't say it, but it stands for the proposition that a plaintiff, I'm going to say this differently. No recovery is available to a plaintiff whose injuries are the direct result of the commission of his, her, or their commission of serious illegal or criminal conduct. Right? And I'm going to just double space this so it's easier to see on the screen. So what did I do there? Right? Remember I said we're going to write from general to specific. We're going to write from general to specific. Well, that's really the general thing we're dealing with. That's as general as it gets. No recovery is available to a plaintiff whose injuries are the direct result of his, her, or their commission of serious illegal or criminal conduct. That's what we're talking about here. That's the big picture. That is the general statement. Does that in and of itself answer my questions? Does it have facts? No. But when someone reads this, that's the general idea. So they get it. Okay, they get that's the gist of it. If someone engages in serious illegal conduct, they get no, and they're a plaintiff, they get no recovery. So now we can get more specific. How do we get more specific? We use our case law rules now. Now we're going to start getting some facts involved, these fact-based case law rules that we've researched and put together that make it translatable and adaptable to the facts of our case. All right? Before I do that, though, this is our rules paragraph. In our rules paragraph, we have what? We have citations. So here, I'll make a little note for myself, right? Cite to statute. And again, we're going to do citations, but since we haven't done them yet, what I'm going to tell you is after that rule, right? That general rule from the statute, we're going to cite to the statute, which is NYCPLR section 1411, right? But now let's get into the case law rules. So, get my notes here. All right. A plaintiff, this is going to be the Barker case, in a personal injury action whose attempt to construct a pipe bomb which explodes in his hand is completely barred from recovering damages. So this is just one of those case law rules. It might be worded a little differently because I'm working off a different sheet than I did for Module 3, but we all remember that case. That was the Barker case when the plaintiff blew his hand off making the pipe bomb. He sued the manufacturer of the pipe bomb parts, and he's barred from recovering damages. All right? And now I gave the rule, and now I would give the citation. Again, we haven't covered citations yet, so I would just say cite to Barker. Easy enough. Okay. So up next we have the case of Manning by Manning v. Brown, the underage stolen vehicle joyriders. So here, a plaintiff, actually we'll say an underage plaintiff in a personal injury action an underage and unlicensed plaintiff, forgot that part, in a personal injury action, joyriding in a stolen vehicle, may not sue for injuries sustained when the car is crashed. So again, maybe a slight variation of the rule that we put from last time. Again, I'm working off a sheet from a prior semester where we might have, the teams might have kind of constructed the rules slightly differently, but you're all familiar with the case. And here I would cite to Manning. Easy enough. Then, all right, last but not least, we have the Alami case, Alami v. Volkswagen. So again, a plaintiff in a personal injury action who is intoxicated while operating a motor vehicle, resulting in a fatal crash, may still recover his or her damages. Right, that's the rule. And then I'm going to cite to the Alami case. Easy enough. 4 rules. We start with the most general. We get more specific with the facts. And then we put a citation after each one of the rules, just from the case it came from, or if it's the really general rule from the statute. Now, I want to point a few things out. All right, we're going to go back. We're going to edit this a little bit. One of the more effective techniques in legal writing, or in writing in general, is the use of what we call transition words. The use of what we call transition words. What transition words do, a transition word might be however, similarly, on the other hand, conversely. These transitional words, these transitional phrases help direct a reader so that they understand we're either continuing and building upon that same train of thought, or on the flip side, we're now sort of reversing gears a little bit. Here's what I mean, all right? Let's take a look. So, no recovery is available to a plaintiff whose injuries are the direct result of his, her, or their commission of serious illegal or criminal conduct. Great, we cite to the statute. Then we come in with this case law rule, a plaintiff in a personal injury action whose attempt to construct a pipe bomb which explodes in his hand is completely barred from recovering damages. Cool, right? Then we get this next thing going on. An underage and unlicensed plaintiff in a personal injury action joyriding in a stolen vehicle may not sue for injuries sustained when the car crashed. Well, I'm kind of getting into this habit of starting with a plaintiff, a plaintiff, a plaintiff. And what I want to do is use transitional phrases and transitional words in my legal writing to indicate to the reader whether I am continuing on the same thought and building upon it, or I am shifting gears and now giving you a different thought. So right in this one, what I would do, right, I would use the term similarly to start that sentence. And I would spell it right. So now when you read those two sentences together, you read about the Barker case, the rule from Barker, and then you see the word similarly. Okay, this is another case where someone did something. This is another case where a plaintiff did something and they were not allowed to recover damages because it was illegal conduct. Does that make sense? Right? But then, look at this last one. Plaintiff in a personal injury action who was intoxicated while operating a motor vehicle resulting in a fatal crash may still recover his or her damages. May still recover. This is a different thought. In Barker, they could not recover. In Manning, they could not recover. But in Alami, they can. So here, right, instead of doing moreover or further or some other form of transitional word or transitional phrase that indicates we're keeping the same thought, instead what I'm going to do is use the word however. So now a reader gets, okay, however, this is going to be a different this one. So on a subliminal subconscious level, what are we actually accomplishing? What are we doing here? We're accomplishing, right? We're accomplishing and letting the reader know these cases are the same and now this case is different. We're helping them understand it just by the words we're using and grasp it on a subliminal or subconscious level. Very effective way to conduct our writing. Now, something else you might notice is this. These two cases, the two where it did not work out for the plaintiff, where the plaintiff's conduct was illegal, seriously illegal, they go together, and then I end with this one. Imagine if I switched them up, right? So if I started with Barker, and then instead I did Alami, so I used however, and then what am I going to do again? I got to do, if I come back to Manning, I need to use the word, instead of similarly, it's now the Alami case leading, and I need to use a word like conversely, or on the other, a phrase like on the other hand, or differently. I don't want to do that. I don't want to do that, right? Why? It's just not good writing. Remember what we're trying to do. We're trying to help somebody understand this. And transition words, transition phrases are a great tool to help them understand it. No question, no doubt. Okay? But if I'm like, this happens, however, this happens, but no, this happens, but no, conversely, on the other hand, this happens too. Do you see how it becomes kind of like a ping pong effect, right? It becomes kind of a ping pong effect. And what leaves the reader a little bit confused. The reader's got to do what? The reader's like, wait, what? The reader's got to take a step back and read it again. So what I like to do, in addition to using these transitional words and transitional phrases that help guide the reader's thought process, I like to organize all the cases that fall in one category together, and then any cases that are different in another category, one after the next. So not only is the reader knowing what thought process to follow, but they're not getting confused by going back and forth. It's easier and more efficient and more effective and just an all-around better way of doing it, in other words, to put cases with the same outcome one way and cases with different outcome and group those together after that. You see? Group the cases that are of a similar outcome, similar nature together so the reader can more easily follow what's going on. And that right there is a rules paragraph. Easy enough, right? I'm just going to give this a little tab. Good. That is our rules paragraph for the issue of serious legal conduct barring recovery. And then now, let's make those arguments. We're going to make our arguments, use comparisons, and make a prediction at the end of the day, right? So, as a matter of practice, and again, effectiveness in legal writing, what I like to do is I like to start with the weaker argument first. So in my head, I know who's going to win and who's going to lose this argument. I already know what my prediction is going to be. And based on our work in our face-to-faces and our previous live stream lectures, you all know that it's very likely Mr. Hessler's conduct wasn't serious illegal conduct. That's the conclusion that we pretty strongly all agreed upon. So whose argument do I want to start first with then? I like to start with the weaker argument first because that allows me to make the weaker argument first, essentially kill it with the stronger argument and lead right into the prediction. From a writing standpoint, again, if I start with the strong one, then I go to the weak one, then I got to find some kind of way to come back to the strong one. You see what I'm saying? Again, I'm ping-ponging back and forth, confusing the reader. Me personally, and I think the best way to do it, start with the weak argument, go into the strong argument, and once they hear how strong that argument is, it's going to logically flow into your prediction. Just a much better strategy of approaching your writing than having to worry about going back and forth. It'll be easier for you, number one, but number two, it's also going to be easier on the reader as they're reading it. So let's make this argument. So the weaker argument for this would be for Miss Novick. And on this issue, Miss Novick really just has one argument to make, right? Miss Novick may argue that Mr. Hessler is not entitled to recovery because he engaged in illegal conduct by looking down at his cell phone to make a call while driving. That's really the only argument she has. We've been over it, right? Miss Novick's going to say, look, he gets nothing because he engaged in illegal conduct by looking down at his cell phone to make a call while driving. All right? Again, transition word. Transition word tells the reader, look, now I'm switching to Hessler. Conversely, Mr. Hessler may argue that this case is different than, and I'm going to use the cases we just used for the rules. It's different than Barker. It's different than the Manning. And even different than Alami, to be honest. And I got to say why. So, why? Because he did not engage in such extreme conduct as doing what? Constructing a pipe bomb, unlawfully joyriding underage, while underage, or driving while intoxicated. All right? So Hessler, what am I doing? I am making his argument by saying, look, this case, Hessler's case, is much different than these other cases. That's his argument. Novick really doesn't have an argument to make about the cases. Hessler does. So we're going to argue that these cases are different because the conduct in those cases is very extreme and his was not. Okay? Then, right? Moreover, Hessler's argument's the better one, so we're going to have more to argue here. Moreover, even in Alami, where the plaintiff crashed an automobile under the influence of alcohol, recovery was still allowed. So what are we doing here? We're saying, look, Hessler's arguing our case is so much different than those other three cases from the rules paragraph. That's all really extreme stuff. He did not do extreme stuff. He looked down at his cell phone when he's driving. And on top of that, even in one of those cases, the Alami case, the recovery was still allowed, even though plaintiff was drinking and driving and crashing the vehicle. So that's Hessler's argument. The behavior in comparison was not as extreme, and even in one of those cases, the plaintiff still got paid. I should still get paid too because my behavior is not as extreme. Pretty simple, right? We made the best and only argument that Ms. Novick can really make, and we followed up by now making Hessler's arguments, which are and we all agree, stronger, because we can make clear comparisons and distinctions with those cases, their outcomes, and say that even in one of them, drunk driver gets paid, so should Hessler, right? And that leads us to, of course, the prediction. Now, the predictions are, again, very easy to do. Therefore, I always like starting them with therefore. You could start it with accordingly. Maybe we'll do that for the next one, accordingly. But therefore what? It is likely. We can't say for certain, but we can say, which is a prediction. It's not etched in stone, but it is likely that a court always gets capitalized, by the way, if you're a lawyer, will not find that Mr. Hessler did what? Engaged in serious illegal conduct, barring him from recovery. So I like to start it with a transition word or phrase that says, looking at this all together, the two that I like is therefore. I like accordingly. I use that a lot. In conclusion is a good one. And then the key is, right, we don't say for sure. We say it is likely. It is likely. This is a prediction. It's not again, a 100% accurate reading of the future. We feel good about it, but we can't be certain. We don't know how a judge is going to rule. We don't know how a jury might rule. It is likely that a court will not find that Mr. Hessler engaged in serious illegal conduct, barring him from recovery. And that's it. So the prediction is very straightforward. Start with a conclusory of some sort, transitional phrase or word, and then it is likely or it is not likely, and finish, make your point. That's it. But it needs to be in there. It's important. All right? And there, right, you kind of have it. All right? We're going to do one more just to really bring it home. Let me see if I can get this all on one page. But that is a discussion of an issue right there. We have our general rule. We have our more specific case law rules under it. We have our citations. We have the weaker argument made by Ms. Novick. We have the stronger argument made by Mr. Hessler. Then we have our prediction. We use the transitional phrases and transitional words to help guide the reader through it. We organize similar outcomes. We organize with weaker argument before stronger argument, right? And we end with our prediction. Really straightforward, and a formula that if you follow, you really can't go wrong. So just to really hammer the point home, let's hit this one more time. All right, we'll use now the percentage of fault issue. I'm going to go back to making it bigger. All right, and let's get this one down. So again, we're starting with a general rule, right? So a plaintiff's damages, this is the general rule right under the statute for percentage of fault. A plaintiff's damages are diminished by the percentage of damages attributed to plaintiff's conduct. Boom. All right, that's the general rule. All right, whatever percentage of fault you have for you, your damages will be diminished by that percentage. And I just want to double space this so it looks better on the screen. All right, what do I cite? Cite to the statute. That's from the statute. Now I can get more specific. All right, now I can get more specific. A plaintiff in a personal injury action who drunkenly walks on train tracks at night and gets hit by a train may still recover 25% of his, her, or their damages. That was from the Soto case. So there I would put my citation in, cite to Soto. Up next, transition word. Additionally, building upon that same point. We're following the same logic. We're not shifting gears. We're continuing. A plaintiff in a personal injury action who recklessly drives an ATV and crashes into a tree may still recover 8% of his, her, or their damages. And that one is from the Whalen v. Kawasaki case, so I'll leave myself a little note. Question from Jesus. For the sentence that starts with conversely, Mr. Hessler, is it he did not engage or he did engage? Let me go back up. It's Mr. may argue because he did not. Yep, good catch, Jesus. Sorry about that. You all see that? Because he did not engage in such extreme conduct. Thank you, Jesus, for pointing that out. All right. Back to here, and this would be the Whalen case v. Kawasaki Motors. And now this one's a little bit different. I'm finishing with the one that I really like. So I'm going to use further here because we're still kind of making the point that, look, you could do dumb crap and get paid for it still, and there's some percentage. So this one, they're kind of, you don't need a however, you don't need a conversely. You got to just feel them out, right? So further, a plaintiff in a liability lawsuit, change it up a little bit, who crashes his, her, or their vehicle while driving intoxicated may still recover. So I end on the high note. 60% of his or her, his, her, their, his, her, or their damages. Cool. And that was the Humphrey case, Humphrey v. State. Cite to Humphrey. Easy enough. Those are my rules. Transition words, organized in a logical manner. And now let's hit our arguments. Okay. Again, right? What is Novik's argument? She doesn't really have a great one. So we're starting with Novik again. Miss Novik may argue that what? Really, the only argument she has is that Mr. Hessler's damages should be significantly diminished because he engaged in the negligent act of what? The negligent act of looking down at his cell phone. She's stuck. That's the only really drum she can beat in this argument, in this case. And with regarding these issues anyway, engaged in the act of looking down at his cell phone to make a call while driving. And in this case, I might throw in immediately prior to their collision, because we're talking about contributory negligence. Great. Okay. That's all she's got. Because Hessler, again, has the really strong hand here. On the other hand, now that's signaling the reader we're looking at Hessler. On the other hand, Mr. Hessler may argue that this case is different than Soto, Humphrey, and Waylon because the plaintiffs in those cases recovered damages in percentages ranging from 8% to 60% for engaging in extreme conduct, whereas all Mr. Hessler did was simply look down at his cell phone to make a call while driving. Boom. All right. Sounds pretty good to me. Again, that extreme spectrum argument. Accordingly, it is likely that that a court will allow Mr. Hessler to recover more than 60% of his damages despite his conduct. Boom. Question from Darley. Darley says, will each memo include a section for percentage of fault? Do you mean, clarify for me. Let me know if you mean within, in this class, like your final memo. Yes, what I'm writing now, everything should be in your final memo. I'm literally giving you 2 whole sections for your final memo. In terms of the law in general, no. It would depend on the legal issues. If it's a contract case, there's no contributory negligence in a contract case. If it's a real estate case, there's no contributory negligence. If it's a family law case, divorce, child custody, that's not how they do things. So the concept of contributory negligence and percentage of fault, to answer Darley's question, is unique to a case involving a claim for negligence, which is what Hessler's bringing against Novick. So should it be in your memo? Yeah, everything I'm writing should be in your memo right now. Literally, this should be off my screen and into your memo. Again, that's going to make your life really easy at the end of the semester if you're doing the right stuff. But as a general rule or general proposition, contributory negligence and a contributory negligence analysis is only applicable where the plaintiff's claim is for negligence. They go together, they fit together. So it's not uncommon to see a contributory negligence being analyzed as an issue in a negligence suit in a memo. But I can't, as a general rule, say all that. All right? Hopefully that answers your question, Darley. And there we go. We got 2 issues down. All right? Again, rules paragraph, argument and prediction paragraph. Got my rules. They start general. I'm going to have my citations. Use my transition words and phrases. And my arguments. Start with the weak argument. Transition to the strong argument. Kill it at the end with that prediction. And I should have said it is likely there. It is likely. All right? Easy enough. So that leaves what? The hard work. We just did the heavy lifting. We did the hard work. Now let's frame these issues. So right here, we got 2 issues. I like to number them. I think it makes life a little easier. So we'll number these. The first issue is what? Whether looking down at a cell phone while operating a motor vehicle, to make a call, let's be more specific, to make a call while operating a motor vehicle. Actually, we'll say while driving. Even better, while driving constitutes serious illegal conduct, barring recovery under New York, CPLR, section 1411. Boom. And no, remember, specific and general at the same time. I'm not talking about Hessler. I'm not talking about Novick. I'm just talking about the facts. All right. Now this one will be a little bit different, okay, because we're dealing about percentages here. What percentage of fault or actually say what recovery, what percentage of damages, we should say, that's the best way of saying it, may a plaintiff who looked down at a cell phone to make a call while driving recover under New York CPLR section 1411. So this one I had to frame a little differently because we're asking for a percentage. Jesus is asking, can I zoom in a bit more? Yep. All right. So our first one is whether looking down at a cell phone to make a call while driving constitutes serious legal conduct barring recovery under NY CPLR 1411. And then our second issue is what percentage of damages may a plaintiff who looked down at a cell phone to make a call while driving recover? So we're very specific. We're making no bones about what Mr. Hessler did. It's very clear. The facts are very clear. The facts are very specific, but I'm not mentioning Hessler and I'm not mentioning Novick. So it's general in terms of the parties, but specific in terms of the facts. All right? Now, literally, from my conclusion, I'm going to copy these, save myself some typing, especially when I'm on live stream. Hit these up, right over here. Paste them on, right? And we know that the answer to this is this: looking down at a cell phone to make a call while driving does not constitute, that's our prediction, serious legal conduct barring recovery. Change that. Mirror image, literally, copy paste. Copy paste, can't be any easier. And then here, we got to change this one up a little bit. Unfortunately, we got to change this one a little bit, but y'all get the point, right? Yours is actually going to be easier too. Plaintiff who looked down at himself to make a call while driving may recover more than 60% of their damages. And we'll change this, right? So that one, we needed a few more cosmetic changes, but typically speaking, issue 1, that's far more in line with what is to be expected in terms of transitioning a issue statement or issue question into a conclusory statement, okay? But again, no mention of Hessler, no mention of Novick, just talking about the facts. And then at the end of the day, speaking of facts, that's where we leave off. So what actually mattered here? There's really only one fact that mattered here. Hessler looked down at his cell phone to make a call while driving. What is Olivia wants to see the top real quick? Right there. Is that what you want, Liv? Conclusions? Give me a thumbs up if that's what you want, Liv. I'll show you what you want to see. I just need to know what you want. But that's the issues. Oh, the issues, sure. There you go. All right, and actually I can multitask right now, so I'll keep those issues up there for y'all to see. But the facts here, it's really simple. Right? I might give one sentence just to give a quick overview of what went on. Our client, Edwin Hessler, good. Our client, Edward Hessler, was involved in a head-on automobile collision with Miss Betty Novick. Immediately prior to the collision, Mr. Hessler glanced down at his cell phone to make a call while his vehicle was in motion. Boom. That's it. You know, you're going to add more to this because you have more issues, right? But for this, if we're pretending that this is one memo for just these two issues, the other two issues don't exist, okay? This is all you need. If I was writing a memo for only these two issues, that's what I need, okay? So yeah, there's things that you're going to want to work in because it's broader. We have two more issues to consider. One you're going to do in your face-to-face team meeting. The other you're going to do on your own, but you should have everything you need for it, more or less. So you'll add more facts. But again, I don't need the life story of Edwin Hessler. I just need what I need that we discussed in the discussion, and that's included in our issues. All right? And that is it. That is it. That is the memo.